Hello, my name is Jim Soberay. I'm the president of Brinks, Holford, Gilson & Leone. It's my pleasure to welcome you today to our presentation on 2013 IP developments. I'd like to start with a quick look back at 2012. We continue to see headlines involving important developments in intellectual property. We saw several billion-dollar verdicts handed down. We saw some recent decisions from the Supreme Court, some of which will continue to have an impact on your company today and throughout the year. In fact, we'll talk about some of those decisions in our program later today. Of course, we also saw further changes to the U.S. patent law as a result of the American Invents Act. Important changes to the law went into effect in September. We'll continue to deal with some of those effects this year, and some more changes, very important changes to the patent law will go into effect in March of this year. That's when we adopt a new first inventor to file system. In fact, it's such an important topic that we won't have time to address it today. But next week, we're going to have another presentation like this devoted exclusively to things you and your company should be thinking about now in light of the changes that go into effect in March. We hope that you join us. Now, today's program is going to focus on three topics that we think will be of importance to most companies. Those are some recent developments in the International Trade Commission, patent eligibility of computer-implemented inventions, and trademark enforcement. In the ITC, we continue to see a shift in enforcement strategies by patent owners to take their cases from the district courts to the International Trade Commission. If you haven't been in an ITC case yet, you could be in the near future. And there's some important recent developments that you'll want to be aware of. The second topic is patent eligibility for computer-implemented inventions. Now, some of you are in companies that innovate in that space, but even if you're not, most likely your company uses computers and the internet in one way or another as part of carrying out your business, whether it's communicating with customers or suppliers. And even if you're not obtaining computer-implemented invention patents, you may be facing them from companies seeking a license or seeking to enforce them against you. So I think most companies will want to be aware of the evolving standards of patentability that relate to these types of inventions. And that will be our second topic today. The third topic will focus on trademark enforcement. Now, there's many aspects of trademark enforcement. The three we'll focus on today have to do with first, preliminary injunctions. What are some of the things you should be aware of and thinking about if you're in a situation where you need to quickly enforce your trademark rights? Or if you're on the receiving side, what are the things you should be doing to defend yourself? The second trademark topic we'll talk about are some pitfalls that trademark owners can fall into unwittingly if they grant what's called a naked license. And third, we'll talk about a recent decision from the Supreme Court that gives trademark owners a relatively easy way to cut off litigation challenges to the validity of their trademarks. Our first speaker today will be Carl Charneski. Carl is a retired administrative law judge from the International Trade Commission. In fact, he's the only retired ALJ in private practice today in the U.S. He also co-chairs our ITC practice group. Our second two speakers will be John Nethery and Amir Penn. John and Amir have years of practice preparing patent applications, of prosecuting them, and counseling clients on computer-implemented inventions. They're very well schooled and experienced to speak to us on the evolving standards of patentability for computer-implemented inventions. Our third speaker will be John Gabrielides. John is the chair of our trademark practice group and eminently qualified to talk about all aspects of trademark enforcement, and he will be our cleanup speaker today. Before we delve into these topics, I would just like to take a minute or two to tell you a little bit about our firm. It's our sincerest commitment here at Brinks, Holford, Gilson & Leone to help our clients achieve their legal and business objectives. We help clients with comprehensive IP strategies that are tailored to their individual needs. We help companies identify their IP assets, procure IP protection, manage their IP portfolios, and enforce and defend their IP assets. We have a deep roster of IP experts in every aspect of intellectual property law and in every field of technology and science. We have over 165 attorneys and patent agents that work full-time in all these areas of IP and technology. That makes us one of the largest full-service IP firms in the country. We have 7 offices nationwide. Our headquarters is here in Chicago. We also have 2 offices on the East Coast, one in Washington, D.C., and one in Research Triangle Park, North Carolina. We have an office out west in Salt Lake City, Utah, and we have a strong core here in the Midwest. In addition to Chicago, we have offices in Indianapolis and 2 offices now serving Southeast Michigan. Our office in Ann Arbor, Michigan, and our newest office, which is in Detroit. In fact, the Detroit office is located on the ground floor of the same building that houses the USPTO's Detroit satellite office. So we're glad to be neighbors with the USPTO in Detroit, and we hope if you're ever in Southeast Michigan and have business in that patent office, you'll come and visit us. Now, I would like to introduce our first speaker. That's Carl Charneski, who's going to talk about some important recent developments involving the International Trade Commission. Carl?
Oh, okay. Thank you, Jim. Now, what does the U.S. International Trade Commission hold for us in 2013? And in thinking, well, how to approach this issue, I'm going to begin with an unlikely start, and that is the new faces of the ITC. When you think of the ITC or the Commission, you think of this brownstone building in Washington, D.C. But yet, who are these people who are deciding major issues that affect the lifeblood of your company? The ITC is composed of 6 commissioners, 3 Republican, 3 Democrat, and it's provided by statute that their terms would not exceed 9 years, and there's a rotating chairmanship. Now, of the 6 commissioners, and this deserves a look, we have Chairman Williamson and Commissioner Pinkert, and they will be with the Commission through 2014-2015. Now, here's where it gets a little bit interesting. We have 2 commissioners that are sitting right now, Commissioners Pearson and Aronoff, whose terms have expired. So at some point, you would expect in the near future, there will be 2 vacancies. All right, we'll expand to the full commission. Commissioner Johansson and Commissioner Broadbent are recently appointed and fairly new to the ITC. So where does this lead us? Suddenly you have, of the 6 commissioners, you're going to have 2 new commissioners, 2 older commissioners, and you're going to have 2 new appointees. Now, the Commission has a history of acting in a consensus-building fashion. In the past, there have been few dissents, and when there have been dissents, they've been fairly mild. So when you have 4 of the 6 commissioners being new or fairly new, will the dynamics change? But the changes at the ITC don't stop there. The position of General Counsel is presently vacant, and this is a key position. For example, the 4 commissioners that will be at the ITC for the foreseeable future, they have backgrounds in trade. They didn't have any experience or substantial experience in Section 337 investigations until they came to the ITC. And where do they get that experience? They get it essentially through the General Counsel, who acts as their lawyer, who breaks down the Section 337 investigations and gives them an explanation as to what is happening in these investigations and what are their options. The General Counsel also represents the ITC before the Federal Circuit. Another key vacancy currently is the Director of the Office of Unfair Import Investigations, or OUII. OUII has a key pre-institution investigation role, and in cases selected by the commissioners themselves, OUII represents the public interest. So what this means is that the director of OUII has a chance in certain key commission investigations to offer their view as to how the case should be resolved. And the commission is going to pay close attention because the commission specifically requested their view. So as a result, this slide summarizes the new roster. It may be that in a year and a half from now, we look back and we say, well, there wasn't a change in the commission step or the commission's rhythm, but the fact of the matter is, if you are before the ITC or if you may be before the ITC in the future, you should be aware that the dynamics of the ITC could be changing. Now, before we talk about what's hot and what's not at the Commission in 2013, just a word about the Commission's docket. Why? Well, because people seem to be, Commission watchers seem to find that interesting. And the reason for this is that in 2011, the Commission had a record high 69 investigations instituted. And this fell to 40 in 2012. Well, I guess if you're a lawyer, it's a matter of concern. But if you're watching this V panel and your client is your company, well, you should look at these numbers differently. 69 investigations is an unsustainable number for the Office of Administrative Law Judges, who essentially do the heavy lifting at the Commission and help the parties create the record, which eventually moves down the system to the Commission and then to the Federal Circuit. If we're talking 40 to the upper 50 investigations, keep in mind that there are 6 judges. What that means to you is that the Commission will be able to keep its investigations on a rapid pace, which is a matter of pride with the ITC, and that the decisions flowing from those investigations will be of a higher quality. Okay, so we've talked about the new face of the ITC. We've disposed of the docket matter as being essentially a non-issue, and actually it's good news for parties before the ITC. Now in 2013, the major issue is FRAND, and a potential issue will involve NPEs or non-practicing entities. Now on the FRAND issue, SSOs typically require their members to disclose patents that could encumber the industry, the standard essential patents, and to promise to license them under FRAND terms. And that's something that probably everyone knows. So the question arises, can the holder of a standard essential patent obtain an injunction against an alleged infringer, or is obtaining an injunction on a standard essential patent inconsistent with the promise to license the patent on FRAND terms? In other words, if you have a FRAND encumbered patent, can you come to the ITC and get injunctive relief through the issuance of an exclusion order? So the issue of FRAND licensing terms is front and center before the Commission. How did it get there? Well, it got there primarily through the smartphone war cases. These aren't the only cases or investigations before the Commission that raise FRAND issues, but they're the issues that are right before the Commission right now. We have the 745 investigation involving Motorola and Apple, the 752 investigation involving Motorola and Microsoft. And interestingly, both these investigations raised FRAND issues, were before the full Commission, and were remanded to the administrative law judges, where they remain right now for non-FRAND related issues. But what we do have before the Commission is the 794 investigation, and this is Samsung v. Apple, and it raises directly FRAND issues to the ITC. Okay, so we have FRAND issues before the ITC, and what's interesting is we have heavy hitters outside the ITC that are weighing in. The first is the Federal Trade Commission. In July 2012, the FTC expressed its concern to the Senate Judiciary Committee that ITC exclusion orders may not be appropriate in cases involving standard essential patents whose owners agreed to license the patents under FRAND terms. The Department of Justice weighed in and gave similar testimony to the Senate Judiciary Committee, and both the FTC and the Department of Justice suggested that if the Commission or the ITC can't get it right, then maybe Congress ought to do so. And then the USPTO has weighed in. And the director of the USPTO has expressed concern that standard essential patents are becoming the new front in the tech patent wars, and that the issuance of an exclusion order at the ITC could have, quote, tremendously negative effects. The director of the USPTO, on the other hand, said, well, so too, if there's misuse or abuse of a FRAND encumbered SEP, that creates problems to industry also. So the director suggested that there should be a study of some sort. So we have this perfect storm. We have the issues being teed up before the Commission regarding FRAND, and we have the Federal Trade Commission, the Department of Justice, and the USPTO weighing in on the issue. And you can't help but think it's sort of like the reference, whether it was to Yogi Berra or someone who said, don't look back, they might be gaining. Well, the commission could focus on ITC, on the ITC investigation, but it can't be, or it has to be cognizant of the fact that there is huge interest among the FTC, Department of Justice, and the PTO. So we have the 795 investigation, and the commission has raised 3 questions. And the commission has asked the parties and the public to comment. Question 1, does the mere existence of a FRAND undertaking with respect to a particular patent preclude issuance of an exclusion order based on infringement of that patent? And in the 794 investigation, OUII said no. OUII said that a commission judge can hear the investigation, that the commission can issue an exclusion order for infringement of a FRAND encumbered patent, and that if FRAND terms have to be determined, that the judge can do it at the investigation. The second issue that the commission asked to be addressed was where a patent owner has offered to license a patent to an accused infringer, what framework should be used for determining whether the offer complies with the FRAND undertaking? And finally, for you conflicts of interest buffs, the third issue, what evidence in the record explains the legal significance of Samsung's FRAND undertakings under French law? So what we have here, we have, at least in the 794 investigation, we have the FRAND issue before the commission. We have FRAND issues that were before the commission in the 745 investigation and the 752 investigation now before the judge. And there's considerable interest among companies across the United States. When the commission took the 745 investigation under review, it posed 9 questions to be addressed. In the 752 investigation and the 745 investigation, the FTC submitted third-party statements expressing its position. And in the 752 investigation, several U.S. senators also expressed concern over this issue. And finally, on January 8th, 2013, just mere days ago, the USPTO and the Department of Justice provided the ITC with a joint policy statement expressing concern with the issuance of exclusion orders on FRAND encumbered standard essential patents, and suggested that before the ITC in a particular case were to issue an exclusion order, that it provide time for the parties to go to an arbitrator or to a court to determine the FRAND terms, and then, when that's completed, to allow the infringing respondent to either accept the FRAND terms or to accept an exclusion order. We're not quite sure what investigation will yield the commission's position, but it's a decision that's certainly ready for the commission. It's probably one that many people wish were decided yesterday. Another issue that the commission may see in 2013 involves NPEs, or non-practicing entities. And NPEs don't have plants and equipment. They don't invest in labor or capital. But how they get commission jurisdiction is through licensing under the domestic industry provisions of Section 337A3C. Now, in 2 decisions, the commission commented in length on this jurisdiction as it relates to licensing, and that was the 694 investigation and the 753 investigation. And it may well be that the commission feels it's said enough, or it's said all that it wants to on the issue of licensing, but there's a feeling among some in the ITC community that MPEs, or some classes of MPEs, don't belong before the commission, and they'll take every opportunity that they can to press the commission to resolve this issue. Certainly, there are people that are taking both sides on this issue, and given the commission's decision in 753 and 694, frankly, a decision finally resolving this matter as it specifically relates to NPEs would not be a bad thing. Finally, in 2013 what the parties can expect, or what the public can expect, the Commission will continue its efforts regarding discovery. In 2012, it began efforts to streamline discovery pretty much across the board, to provide for restrictions on e-discovery. And in 2013, the expectation is that the Commission will finish the job. No one seems to be against this endeavor. Whether the Commission's efforts actually save parties money, it remains to be seen. And in particular, given the breadth and complexity of recent Commission investigations, one wonders whether any savings received or obtained as a result of this streamlining of the discovery process won't be lost in the black hole of litigation at the ITC. Here you go, Jim.
Thank you, Carl. We appreciate your inside perspectives on ITC practice and some of the recent developments we can look forward to in 2013. Our next speakers are John Nethery and Amir Penn, and they're going to talk to us about patent eligibility standards for computer-implemented inventions. John is the chair of our electrical and computer practice group, and he's going to lead off for us. Thank you, John.
Thank you, Jim. Today, Amir and I are going to talk a little bit about patent eligibility for computer software implemented inventions. And as an overview of where we're going, I'm going to talk a little bit about whether or not this is really an important issue, and to whom might it be an important issue. So we'll talk a little bit about the area of impact first, then Amir will talk about how we got to this state where there's such turmoil about what constitutes a patent eligible invention for patentability. After that, we'll touch very briefly on some practical aspects of what you can do given the turmoil that exists now and that may exist for a year or two to come, perhaps longer. So let's look first at the turmoil around whether computer-implemented technologies are patentable. It seems that today the U.S. is distinguished among the major industrialized countries in the world, on the one hand by its theoretical assertions of a robust patent system in which virtually anything under the sun made by man is patentable. But on the other hand, with regard to its schizophrenia regarding whether those inventions really are patentable, and in what form, and what is the test, and how do we know that what we're filing in the patent office actually will qualify and be upheld by the courts in terms of patentability. But is this really worth worrying about? Well, we can take a look at one of the very traditional technologies in this area. It's the infamous Class 705 business method patents. And you can see that over the last 5 years, there's been a dramatic increase in the number of patents issued out of that class, to the point where today, on average, the patent office is issuing more than 10 patents per day in this very traditional patent classification. I think that this growth in the number of issued patents in this class highlights two major issues. One is, at least two major issues. One is that to generate that number of actual patents, you have to have a substantial number of application filings. So on the one hand, you see that companies do really believe that they have inventions in this area. They are anxious to seek patent protection for it, and the interest in pursuing those types of patents is continuing to increase. On the other hand, the other aspect of this that I think is interesting is with the patent office issuing more than 10 patents per day on average in this technology, you have a great number of existing intellectual property rights that are at risk with regard to this current uncertainty in the United States with regard to what is patentable. So we have two very important aspects of this controversy, and I realize that this is simply with regards to Class 705 traditional technologies. So I did a very informal survey with regard to other patent classifications and use at the patent office, just to do an informal check to see how pervasive is this issue with regard to computer software, computer implemented inventions, data processing technologies being applied across the various patent classifications. And what I tried to do is take a look at some unlikely suspects. So the first class I took a look at was ammunition and explosives. It didn't seem at first like that would be an area with wide-ranging patents in computer and software technology, but it turns out that it's rather easy to find patents in that class that deal with computer and software modeling of ammunition and explosives. So I moved on to something I thought would be a little bit harder, Class 119, animal husbandry. And I thought certainly I would have a harder time finding patents that include claims that deal with computer and software, algorithms, those types of issues. But it just turned out to be too easy. And there's an example of a patent that deals with trying to monitor livestock herds, including software modeling aspects in the claims. So I moved on, just one other. I thought, well, how about Class 168, farriery? I didn't even know what farriery was when I found that classification. It turns out to be the art, essentially, of shoeing a horse. Well, there aren't many patents in farriery, but believe it or not, there is one that includes software and computer technologies, and it deals with an image processing system that monitors the digits of an animal for particular characteristics. So I realize this is a very informal survey, but I think that what it highlights is that there is probably no industry, there's no patent classification, there is no area of technology that isn't impacted by computer software and computer implemented inventions today. So it's a big deal, and we need to know what's going to happen with this. And Amir is going to tell us a little bit about how we got to the point where nobody's really sure how to frame the claims or what is patentable and where we might be going.
Thanks, John. So we'll first take a look at the CLS Bank International case, and that's the latest case in a long series of cases that have created the uncertainty that John mentioned. Now, the claims in CLS Bank International were directed to using a financial intermediary in a transaction, which is fairly representative of claims in this art. Now, a majority of the three-judge Federal Circuit panel held that the claims were patent eligible unless it's manifestly evident that the claims are directed to an ineligible abstract idea. That decision is actually remarkable in two respects. One is that the Federal Circuit actually created a bright line rule. And the second is that they've created a presumption, the presumption being that unless the claims are manifestly evident, that the claims are patent eligible. Now, in light of this decision, the Federal Circuit ordered an en banc review of CLS Bank, and that's what's driving this issue. But then if we take a look back, we can first start with Section 101, the text of 101, which defines the patentable subject matter. It takes a fairly expansive view. Now, the issue is, in addition to the text of 101, the legislative history actually takes an expansive view as well, that anything under the sun that's made by man is considered patentable. We'll also take a look at some of the early Supreme Court cases that start commenting on what is patentable subject matter. There is a general sense as to a theme that that comes from the early Supreme Court cases, namely that fundamental principles such as laws of nature, physical phenomena, abstract ideas are not patentable, yet practical applications of a fundamental principle are patentable, which begs the question, where's the line drawn between unpatentable fundamental principles and patentable practical applications of a fundamental principle? We'll take a quick look at a couple of the Supreme Court cases from over a generation ago, one of which is Gottschalk, which was directed to a method for converting binary coded decimal numerals into pure binary numerals using a computer. Now, the court found that the claims weren't directed to patentable subject matter, and they're basically saying this is an algorithm and nothing more. Now, taking a look at Diamond v. Deere, the claims were directed to basically curing rubber using a measured temperature and equation. And the Supreme Court looked and said, listen, the computer itself is adding something. There's a synergy there. Where using the computer significantly lessens the possibility of over or under curing. Now I want to take a look at some recent Supreme Court cases, first of which is Bilski, which is directed to price fluctuations, reducing price fluctuations by hedging. And it's interesting to note that the Bilski court avoids a hard and fast rule. They look and say, comment on the Federal Circuit's treatment of them and says, simply using machine or transformation test is not the sole test. So they're avoiding a hard and fast rule. And they're also looking to see at certain factors, namely simply adding a computer to implement an abstract idea doesn't render the claims patent eligible. Likewise, restricting the field of use, for example, to energy markets, does not make the claims patent eligible. The latest Supreme Court case is Mayo Collaborative, where the court unanimously found that the claims were patent eligible. The claims in this case were directed to determining a correct dosage for the drug theoprene by trying to measure what was metabolized in the body. What's interesting is the court reasoned that the claims were merely directed to instructions that apply a law of nature. Again, the Mayo court avoids a bright line test, and they focus instead on the various factors that make claims either patent eligible or ineligible. But it's interesting to note two things. One is that the court focused on whether the claims are merely directed to conventional activity or to some sort of inventive concept, which is interesting because it seems like there's a blending between a 101 analysis for patent eligibility as well as a 102/103 analysis for novelty and non-obviousness. And another indicator which is interesting is that does the patent inhibit further discovery? That being an indicator to determine whether you're claiming a fundamental concept. Now, just looking at one Supreme Court, one Federal Circuit post-Bilski case is SIRF Technology. And again, the Federal Circuit in this case actually focused on a practical application, namely looking to see whether a piece of hardware, in this case a GPS receiver, is necessary to the claimed invention. Again, the Federal Circuit in this case avoids a bright line rule, unlike the CLS Bank International case, and instead looks at the various factors. So now we're going to go back to CLS Bank. And in ordering the en banc review, the Federal Circuit requested briefing on the questions listed. What's interesting is with the first question listed, the court is soliciting input to determine what's the test, which is interesting given we've had over 20 years of case law in this area, and yet we're still trying to determine what the test is for determining whether a computer-implemented invention is patent eligible. Now, the CLS Bank International case, the oral argument will be held on February 8, 2013, and after which the Federal Circuit will issue its decision. The question will be, will the CLS Bank International case go directly to the Supreme Court, or will the Federal Circuit remand it, and then cases either at the District Court and the Federal Circuit percolate, applying the CLS Bank standard, and then that application of the CLS Bank standard, whether that will be reviewed by the Supreme Court. Either way, this issue will go back to the Supreme Court. And with that, I'll hand it back to John.
Thanks, Samir. I think we all know it's very easy for courts to create new standards like avoid an abstract idea or try to figure out whether something is manifestly evident in the claims. But it's very difficult as practitioners to put that into practice. And we only have a couple of minutes here, but I just wanted to take those couple of minutes to get some highlights about what you can do as the patent attorney as a practical matter in the midst of this controversy. It doesn't help you, I think, to try to come up with the test for what's an abstract idea. I don't even think the courts can do that. But we need to do something in the interim while this turmoil is going on. So some of the highlights. Applications that are pending in the patent office. Applications on very important technologies for your companies. It might be wise to keep a continuation pending, if you're getting close to issuance, to keep a continuation pending until CLS Bank is decided and potential Supreme Court review is completed. And the reason is simply that if your patent issues and you have no continuation, you don't know whether those issued claims are going to meet whatever standard the courts decide should now apply in terms of patent eligibility. And if your technology is very important, keeping a continuation on file is a fairly low-cost hedge against decisions that don't work in your favor. But of course, the other reason is that it's tied into the first reason. You just don't know what the new standard is going to be for your claims. So if you can keep a continuation pending until the turmoil settles down a little bit, you may be in a better position to secure enforceable patent rights for your technology. For applications still being prepared, I think it makes sense to spend additional time, and unfortunately that means additional money too in many cases, to write the specification to include practical applications of the technology, reaching even to the effects of that computer system, that software outside of the computer, and in particular interactions with other real-world systems out there outside of the computer. Because let's face it, when a court is wrestling with this issue of whether something is an abstract idea or not, I think as a practical matter, they are falling back to some of these tests that seem like they might be discredited or have fallen by the wayside. Tests like a useful, concrete, and tangible result, or whether the claims are tied to a particular machine, whether there's transformation. I think as a practical matter, courts are looking at these sort of practical implementation issues as they struggle with what is an abstract idea. Whether or not your claims are whether or not your applications are pending, it's all about your claims. You may want to consider spending additional time to write additional claim sets that again include these sort of practical aspects of the technology, your claims reaching out beyond the computer system itself and how those claims interact with real-world entities. It certainly is the case that the Patent Office has a fee system in place that makes it financially difficult sometimes to file lots of extra claims. But one thing you can do, especially if your application is not pending yet, if you're still writing your application, you can write those claim sets with the hedging positions in them. Don't include those in the application as claims, but simply put those in the specification. You can reword them in English, plain English sentences, and then have literal support for those claims later down the road if you need to fall back to that. So of course, with the claims you do pursue, it would be worthwhile to get some input from other patent attorneys to figure out whether your claims are maybe running up against this abstract idea concept. Nobody knows for sure, but it would be helpful to get some advice about, as a strategic matter, where to draw the line with those claims that you want to present. So with those practical aspects in mind, I want to turn it back over to Jim, and we'll move on to the trademark portion of the presentation.
Thank you, John and Amir, for helping us understand this evolving area of the law and for your practical advice on how to navigate these unpredictable waters. Now I'd like to introduce our final speaker today, John Gabrielides, who's the chair of our trademark practice group. John's going to talk about some important aspects of trademark enforcement. John?
Thanks, Jim. I'm here to talk about 3 issues in trademark law that we're keeping an eye on here from our clients and that I think have had some stability in the past but seem to be undergoing some changes right now. So the first one will be irreparable harm in trademark cases. In the past, this has been pretty much of a given for how the courts treat it, but in light of 2 Supreme Court cases, there's been some change in the direction that this issue has. The second issue is naked licensing, which is another issue that historically has been fairly stable, but now, because of a couple circuit court cases, is undergoing some change that requires some reevaluation. And the third is a Supreme Court case. The Supreme Court doesn't usually take on a lot of trademark cases, and they recently decided one on an issue that affects parties in litigation over trademarks. So we'll take a look at that as well. So the first issue is irreparable harm. Now, in many trademark cases, an early move by the plaintiff is to move for a preliminary injunction. It's common. It's also a critical event because it can really signal the begin and the end of a case. Whoever loses that preliminary injunction sees the writing on the wall and promptly settles one way or the other. The standards for preliminary injunctions are well defined. I've put them up on the slide. I want to focus on the third one there, irreparable harm, that I've italicized, because that's where we're seeing a change from what's gone before and where we're headed. And interestingly, we'll see it's not the trademark bar that has created the change, but the Supreme Court in non-trademark cases. The traditional rule was, if you were a plaintiff and you were able to prove a likelihood of success on the merits at the preliminary injunction stage, courts would say irreparable harm is presumed. No further showing is needed. This was great from the plaintiff's standpoint, because you always show likelihood of success, and therefore you didn't have an added burden. It was also more or less a given from the defendant's standpoint. Nobody really challenged this presumption. It was so widespread among all the circuits and districts that there was no point in challenging it. In fact, the challenge, the erosion that we see, comes not from a trademark case, but beginning with a patent case in 2006 out of the Supreme Court. This is eBay. It has a lot of significance for the patent bar, but what it does for the trademark bar is it shows the beginning of the erosion. This was a patent case involving permanent injunctive relief, and there was a given in the patent world that if you prevailed on the merits in the case, you were entitled to a permanent injunction. The Supreme Court here says, no, we still have to use our traditional principles of equity, and you must have evidence establishing the irreparable harm that you claim requires the permanent injunction before a permanent injunction will issue. So eBay gives us a patent case involving permanent injunctive relief, and the court is tightening the standards. 2 years later, in 2008, the Supreme Court takes on Winter v. Natural case, and that's a non-IP case, but it does involve preliminary injunctive relief. And in this case, it came from the Ninth Circuit, where that court had said, look, if the plaintiff shows a strong likelihood of success on the merits, as long as there's a possibility of irreparable harm, we're going to issue the preliminary injunction. And the Supreme Court, following its eBay pronouncement, says that's too lenient of a standard. You still have to demonstrate, because a preliminary injunction is such an extraordinary remedy, the plaintiff has to demonstrate a clear showing of irreparable harm before the preliminary injunction will issue. So now we have, in this Winter case, a non-IP case involving preliminary injunction, and again, you can see the drumbeat getting tighter and tighter. So what happens in the trademark world? Well, what happens is that the district courts start saying, well, if we take these two cases together, we see the Supreme Court is not very fond of presumptions for preliminary injunction cases, and in fact, we're going to start requiring actual proof of irreparable harm. And I've put some cases up on the slide, and my favorite is out of the Eastern District of California. The governing law has changed in light of Winter. Now a plaintiff is not granted the presumption of irreparable harm. That's a pretty direct showing that judges are not inclined to give you the presumption anymore. Similar cases come out of the 5th Circuit, 11th Circuit, Northern District of California, and District of Oregon. So you might think there's now unanimity. It's not so. There are courts that say, well, we're going to stick with the presumption. eBay and Winter, those aren't trademark cases involving preliminary injunctions. So the Ninth Circuit, for instance, in 2009, which was after the Winter case, says because the lower court, found a likelihood of success, we're going to presume irreparable injury. So that's one case going the other way. Interestingly, many courts sidestep the entire issue because I don't think they know what to do. So they say, well, we're not really sure if there's a presumption of irreparable harm, but you know what? We looked at the facts and we find it here anyway on the evidence. So it satisfies this burden. That's kind of a sidestep. So what does this mean for litigants and parties when they're facing preliminary injunctions? Well, it looks like you have to undertake a circuit by circuit, district by district, and maybe even judge by judge analysis before you go into court, or once you're in court, to find out how they're handling this presumption. The winds are just not that easy to read right now. The Supreme Court case is not given much clarity, although we think the trend is to eliminate the presumption. We're watching. The second issue I want to discuss is naked licensing. This too was an issue that was really stable for many, many years, but is now thrown into a little bit of some turmoil. Trademarks 101, very briefly. Trademarks really, the only thing they mean is a single source of consistent quality. That's really the definition of a trademark, whether it's registered or not. once you have a single source showing consistent quality under a particular mark, you have trademark rights. If there's inconsistent quality, there is no trademark. It's that simple. Many times, trademark owners find it lucrative and administratively easier to license others to use their trademarks in connection with goods and services. Very common tool. The license can be oral or written. What's important, though, is that as part of this license, the trademark owner must retain control over the quality of the goods and services offered under the mark. This is called quality control. It's critical. Every trademark license must have it. What are some quick examples? I've listed some on the slides. Maybe you meet objective performance criteria. It has to meet certain stress guidelines. You have to send samples of the product to the licensor once every 6 months. The licensor gets to inspect the premises of the licensee and so on. These are easy examples of quality control that have been used for years. What's the problem if you don't have quality control or if you don't exercise quality control? Well, this is what's called a naked license, meaning that you are allowing somebody to use your mark without controlling the quality. The consistency that we talked about in the Trademark 101 portion of my speech is gone. What are the consequences? Well, there's immediate and there's long-term. The immediate is that the licensee or putative licensee no longer has to pay you. They're no longer under any obligation under what you thought was the license. That's bad enough, but what's worse is that you've lost your trademark against the world because, again, you are allowing somebody to use it without controlling how they use the mark. And importantly, this naked license and the abandonment applies whether your mark is registered or not. Having a registration with the U.S. Patent and Trademark Office doesn't avoid the problem that we're talking about here today of a naked license. Now, for many years, trademark lawyers and practitioners have said, you know, be careful of the naked license. It's but in practice, the number of cases that actually found a naked license are far and few between. In fact, other than the two I'll discuss in a moment, the last one I found was decided in 2004. So it was a nice legal theory, but didn't really have much practical application. That now has changed a little bit, or at least may be changing. In 2011, the Seventh Circuit decides a trademark case. It's a fairly routine case as far as the law goes in terms of infringement. Facts are a little unique. This was a case involving a mark that had been in use since 1966. That's a long time. Marks strengthen with use. The other interesting thing about the case is that it had only been used by the originator of the mark and her family members. She licensed it to children and spouses and grandchildren and so on. It was always kept within the family. One of the licensees wanted to use it under terms of a royalty payment, which they did. But the royalty, the license terminated in 2002. But even though the license terminated, they continued to use it. There was a falling out among the family members. Remember, all family members here. And eventually, the owner decided to sue these family members for infringement, saying, look, the license terminated in 2002, you continue to use it. One of the licensee's defense was, hey, I've been using it since 2002. You haven't been around to check on my use. This was a naked license. You no longer retain control over my use of the mark. You've lost your trademark. The district court on summary judgment agreed in a fairly remarkable ruling, and even in an even more remarkable development in my view, the Seventh Circuit affirmed at the summary judgment stage, saying that the licensor, the family member, no longer controlled the business or the store or the operation of the mark under which the mark was operated, and therefore the trademark is gone. Now, the Seventh Circuit, I think, realized what it was doing because it says, look, this is an extreme case. That's their terminology. There was no authority being exercised over the licensee's business. In my view, what makes this an extreme case is this mark had been used for over 45 years and only by family members. And yet, both courts were willing to destroy the trademark on those terms. What I find surprising is that it was found to be a naked license and the rights were lost under these facts. Now, you might think that this is an aberration, but maybe not. 2 years or a year earlier, the Ninth Circuit, which is another very influential circuit in trademark law, had decided a case, again on summary judgment, affirming that there had been a naked license because there was no established quality control standards. So what do we see between these two cases? Perhaps is the pendulum swinging back? Is the bogeyman coming to life? We don't know. All we do know is that these two very recent cases out of two very influential circuits may represent a resurgence of the importance of quality control. And I should mention that it's important not only to have the words quality control in a written license, but to in fact exercise it. You can't use the license as window dressing. Quality control must be exercised. Okay, the last topic I want to address is the Supreme Court's recent case involving a covenant not to sue. The facts are again fairly standard except for one twist. Nike files suit against a company alleging an infringement of a shoe design. The defendant denies, for trademark infringement. The defendant denies, no surprise there, and files a counterclaim seeking to invalidate Nike's alleged trademark rights. This is a common move. Defendants think that they get some leverage over the plaintiff by keeping the mark in play throughout the case. Nike eventually decides, you know what, this case isn't worth it. I want out. And as part of the terms, they give the defendant a covenant not to sue. Importantly, the covenant is broad. It's unconditional. It applies not only to claims, but to demands. It applies not only to the defendant, but to its customers and distributors. Very broad. Nike's motivated to get out of this suit. And then, predictably enough, Nike moves to dismiss its claim with prejudice, no surprise there, and also moves to dismiss the defendant's counterclaim, saying, look, I've given them a covenant. We have no longer a case or controversy. The district court says, correct. The motion is granted in full. The case is over. The defendant says, wait a minute, I still have my counterclaim, and the subject court still has subject matter jurisdiction because there's still a case or controversy. But the Second Circuit said, no, the covenant really mooted everything, and the Supreme Court affirms, saying, look, once Nike signed the covenant, there was no continuing case or controversy. And what made the case, what sealed this for the Supreme Court was the breadth and unconditionality of the covenant. Everything became moot after that. So what does this mean? What it means is in litigation, the trademark owners do in fact control the fate of their trademarks in litigation. So that if they dismiss the case as part of a covenant, they will take it out of being in play from an invalidity challenge. It also makes counterclaims now a little less attractive for the defendants because it really doesn't hold much weight if the trademark owner dismisses the claim. But note that the covenant must be broadly worded. It cannot simply be something narrow. Is this a good thing? Well, the Supreme Court said something very, very interesting about this. If plaintiffs are inclined to give these covenants, these broad covenants, they said granting covenants not to sue may be a risky long-term strategy for a trademark holder. And why did they say that? That's a naked license that we talked about a little earlier. If you, as a trademark owner, are giving covenants not to sue against a company that you are already on record as being an infringer, all of a sudden somebody's using a confusingly similar mark without any quality control. That's going to add to the drumbeat of the naked license cases that we talked about a little earlier. So with these three developments, what's happening with irreparable harm in trademark cases, the trajectory of naked licensing decisions, and the Supreme Court's pronouncement about the impact of covenants not to sue, we are watching these developments for our clients and suggest that the trademark bar and clients with these issues should do so as well. And with that, let me hand it back over to Jim.
Okay. John, thank you for your timely and practical advice on some important aspects that can affect anyone's trademark portfolio. As I listened to my colleagues, I made a few observations and jotted down a few notes. I'd just like to share these with you in our closing minutes here. In any litigation, it's always important to know the judge and what his or her predilections are and procedures. In the ITC, there's more than just a judge. You have the administrative law judge, who's essentially your trial judge, but also the commissioners who will review his or her decision, the office of the general counsel, and the director of the OUII. And it's important to keep track of all these important players, who they are, what their procedures are, and because all of them can have an important impact on your case. It also sounds like from Carl's comments that we can expect some more headlines later this year from the ITC with regards to how FRAND can impact an ITC investigation. When I said at the outset of this program that computer implemented inventions affect almost every business, I had no idea that it might be an understatement. I didn't realize that could also extend to guns and ammunition, animal husbandry, and I had to write this one down, farrier. So that was a new one for me. But it seems like every business is impacted by computer inventions one way or another, more so than we think. And appreciate Amira and John helping us understand this landscape of the patent eligibility laws, which continue to be changing, and their practical advice for helping us navigate these changing seas of the law. It looks like more changes are coming, and I appreciate the practical advice that they gave us on how patent owners can protect themselves in case the change goes one way or the other. On trademark laws, John really underscored for me just how nuanced trademark law is in several important aspects. Irreparable harm is a key element in any IP case, and John's advice is well taken to get your evidence of irreparable harm before you move for a preliminary injunction. In my experience, I haven't tried this, but I wouldn't try it, and that is, you wouldn't want to go into court and the judge asks for your evidence of irreparable harm, and you say, Judge, we can get that for you. It's better to come into court with it. On naked licenses, it seems to me the takeaway there is be very diligent anytime you let anybody use your trademark rights, even your family members. And then on this recent Supreme Court case, again, very interesting. In one way, it gives trademark owners a real advantage here. You can sue somebody, and if you don't like the way the litigation's going, you don't want to deal with the challenge to your trademark for whatever reason, could be purely economical, not really related to the merits of the case. There's an easy way to get out of the litigation, but then again, you need to think about the impacts of a naked license. So again, a lot of nuances there in trademark law as well. I want to thank you for attending our program today, and I just want to leave you with some closing thoughts. There's two quotations I find very helpful and applicable to when we're counseling clients on intellectual property rights. And the first is from Robert Frost. If you don't know where you're going, any road will take you there. And it just underscores the importance for companies to really have an IP strategy in mind. Rather than being reactive to what your competitors are doing with their IP, it's best to have your own strategy and execute it. And the second quote is from Will Rogers, and he says that even if you're on the right track, you'll get run over if you just sit there. And it just underscores the emphasis of not only having a strategy, but being proactive with it and implementing with it. As I mentioned earlier, we have a team of experts here in all aspects of IP and technology, and if we can help you in any way develop and manage and implement your IP technology, we look forward to working with you. Thank you again.
This concludes our presentation. Don't forget to download the panelist biographies and the presentation before you tune out. We are delighted to answer additional questions afterwards by phone or email. And remember, you must respond to the check-in tracking to get CLE credit. Your certificate of attendance will be sent within 10 business days. Thanks to everyone for joining us.